Meadows tried to argue Donald Trump made me do it. And because he made me do it, I should not be subjected to the black woman in Fulton County who's currently prosecuting me. Judge, can you please just send me to that federal bench to be prosecuted by upstanding old white men? Put it up full mass, where the black judge said, "Hail to the no." I love it. A federal judge has denied a request Friday from former White House Chief of Staff Mark Meadows to move the Georgia election interference case against him from state court to federal court, a shift he had sought on the grounds that he was a federal officer at the time of the actions that led to his indictment. That ruling was brought by U.S. District Judge Steve C. I don't play Jones in the Atlanta-based Northern District of Georgia. Instead, Jones found that the actions, quote, at the heart of the state's charges against Meadows were taken on behalf of the Trump campaign, with the ultimate goal of affecting state election activities and procedures. He added, Meadows himself testified that working for the Trump campaign would be outside the scope of the White House Chief of Staff. Let's put up the picture of his mugshot. Let me tell you why this is so beautiful legally. Because Meadows decided to try his weak ass argument in front of a federal judge, that federal judge now has the ability, as you see demonstrated here, to rule on it and provide legal commentary as to why. So this judge has qualified all of them as working outside of the parameters of the federal government and in fact working on behalf of the Trump campaign. This is a beautiful thing. This is now case law, ladies and gentlemen, that can be used in the prosecution of Donald Trump. It can also be used if anyone else makes the same claim to the federal court. Thank you, Chief Meadows. We appreciate your continued service to the country. All right, obviously his attorney is appealing. Had Mark Meadows prevailed, Jones' next step would have been to consider his request to dismiss the case outright under a legal principle similar to the one he used to argue for removal, that he is immune from prosecution because he was acting as a federal officer. Now Meadows' case will proceed in the Fulton County Superior Court with no opportunity to make that argument. But here's the argument the prosecution can make. The man already admitted guilt. That was the risk he engaged in. He literally admitted he did it, but he was doing it at the command of his boss within the context of his job. But he admits to doing it. Well, that is not an affirmative defense, period. But it is an affirmative way the Fulton County DA is gonna take his ass down. At the heart of the federal removal question is whether Meadows' actions that led to the criminal charges were taken within the scope of his duties as a federal officer. Jones ruled that while some of Meadows' actions that were described in the indictment met that standard, such as managing the president's schedule and attending meetings, others did not, including the broader charge that he participated in the racketeering conspiracy to overturn the election. As a senior official in the executive branch, Meadows cannot have acted in his role as a federal officer with respect to any efforts to influence, interfere with, disrupt, oversee, or change state elections, Jones wrote. Those activities are expressly delegated to the states. Jones also appeared troubled by portions of Meadows' testimony during which he, quote, was unable to explain the limits of his authority. The Federal Hatch Act, Jones wrote, prohibits an employee from using his official authority or influence to affect the outcome of an election. David, brother, I love it when a plan comes together. He has now set the standard ruling for everybody else in the case. What say you?
Yeah, and I agree with you. I love this ruling because I think not enough people know about the Hatch Act, this idea that there has to be a division between your government responsibilities and whatever actions you may be taking on behalf of a campaign. That's why you can't just stand up on the north lawn of the White House if you're a White House official and start spouting things for a campaign. They may in fact be doing that because of their policies, but there has to be the separation. And I also agree with you. Mark Meadows is in deep trouble. For anybody who thinks, oh, well, this is just the Georgia case, it's not the federal case, there are ways to get around local prosecutions. No, he is in deep trouble in this, as is Sidney Powell, as is Donald Trump, and the 15 or 16 other defendants, because this is on an expedited time frame. This trial is going to go first. And again, we've just seen the major victory, the initial victory for Fani Willis in this case. And I think that's why you have so many legal experts saying, don't underestimate her Georgia prosecution here, because RICO cases can be very thorny for defendants.